Hi, this is Alexi from LexaWise. If you're preparing for the real estate licensing exam, this video will help you lock in what you need to know. We'll go through 75 carefully selected questions, each designed to reflect what you're likely to see on the actual test. These questions come straight from the LexaWise database. They're up to date, exam focused, and built by experts who know what it takes to pass. I'll read each question and explain the correct answer in a clear, simple way. You can pause the video at any time to take notes or review a specific point. Let's get into it.
LexaWise, Real Estate Exam Prep.
All right, let's get started with the first question. What type of property listing requires the owner to pay a commission, even if they sell the property themselves? A. Exclusive agency listing. B. Exclusive right to sell listing. C. Net listing. D. Open listing. Think about it. Got it? If you said B, you're absolutely right. The correct answer is an exclusive right to sell listings. That's because in an exclusive right to sell listing, the owner must pay the broker's commission no matter who finds the buyer, even if the owner does. The broker has exclusive rights to sell the property. Other listing types don't require a commission if the owner sells it themselves. Next question. Think you know it? What is the name of the process where one party is substituted for another party in a contract? A. Rescission. B. Novation. C. Redaction. D. Waiver. Take a second. Think you got it? The correct answer is B. Novation, which is a legal concept that refers to the process of replacing one party in a contract with another. The original party is released from obligations, and the new party takes over. This often happens in cases like business sales, where the buyer assumes the existing contract terms. Let's move on to the next one. How long does a listing agreement last? A. Whichever time is negotiated between the broker and seller. B. 100 days. C. 8 months. D. 6 months. Think about it. The first choice, A, is the correct one. Whichever time is negotiated between the broker and seller. The duration of a listing agreement is typically negotiated between the two parties at the time of signing. Let's keep going. What is the name of the lease agreement in which a commercial tenant agrees to pay a base monthly rent of $2,500 in addition to 2% of their monthly gross sales? A. Ground. B. Net. C. Percentage. D. Option. Think it over. The correct answer is C. Percentage. In a percentage lease, a portion or the entirety of the rental amount is determined as a fixed percentage of the tenant's total sales revenue generated on the leased property. All right, next. What option is available to a principal if they no longer wish to have a broker represent them during the term of an exclusive right to sell listing agreement? A. The principal can cancel or withdraw the agency established by the listing contract without being held liable for damages. B. The principal cannot revoke the agency because an exclusive right to sell listing agreement is a contract that is legally binding and cannot be cancelled. C. The principal may revoke the agency created by the listing contract but may be liable for damages. D. The principal may be obligated to sell his property. Pause and think. The correct answer is C, that the principal may revoke the agency created by the listing contract, but may be liable for damages. That's because a principal can end the agreement early, but may owe the broker damages if the termination causes a loss. The listing contract typically outlines the circumstances under which this can happen and the compensation that may be due. Let's move on. What is the responsibility of broker Morty, who has obtained an exclusive listing agreement for a property owned by three individuals and has visited each of their workplaces to obtain their signatures on the contract? A. Provide one copy to any of the three owners. B. Join them together in one place to sign simultaneously. C. Provide a copy to each owner when he or she signs. D. Provide a copy to the first owner who signs only. Take a moment. Here, the correct answer is also C. Provide a copy to each owner when he or she signs. Because in situations where a property has multiple owners, the broker is obligated to provide a copy of the listing agreement to each owner when they sign it. This ensures that all parties are fully informed and have access to the agreement they are entering into. Let's move on to the next question. If a contract is based on an illegal consideration, then that contract is A. Void, B. Enforceable, C. Valid, D. Voidable. Think about it. The first choice, A, is the correct one. Void. A contract based on illegal consideration is void because it involves something unlawful. That makes it unenforceable by law, and neither party can legally uphold it. Next question. Think about it. Which of the following statements about an option is incorrect? A. The optionee has no interest or right to the property until they choose to exercise the option. B. The option rights are assignable unless otherwise noted. C. Even if the option is not exercised, the optioner keeps the money paid for the option. D. The optioner can revoke the offer to sell during the designated period of time. Take your time. The correct answer is D. The optioner can revoke the offer to sell during the designated period of time. An option agreement provides the option holder with the exclusive right to buy or lease the property within a certain period, and the optioner is usually bound by the terms of the agreement. All right, let's keep going. Which of the following does not represent an essential element of each valid contract? A. Valuable consideration. B. Proper writing. C. Offer and acceptance. D. Capable parties. Pause and think. B is the right choice. Proper writing. A contract can be considered legally valid even if it is not in writing, and it may not always require performance to be deemed valid. The four key elements that must be present for a valid contract are offer and acceptance, lawful object, capable parties, and valuable consideration. Let's move on to the next question. In a lease agreement, which party holds the leasehold interest? A. The lessor. B. The owner. C. The landlord. D. The lessee. Think it through. The correct answer is D. The lessee. The leasehold interest is the tenant's right to use and occupy the property during the lease term. The lessee holds this right to occupy it, but the actual ownership always stays with the lessor. All right, here comes the next one. An example of a cost associated with owning a home is A. Land appreciation. B. Appreciation of improvements. C. Amenity value. D. Loss of interest on an owner's equity. Take a second to think it through. So, D is the correct option. Loss of interest on an owner's equity refers to the opportunity cost of tying up your money in the property. Instead of earning interest through investments like stocks or savings, that money is locked into the home, so you lose the potential to earn elsewhere. Let's move on to the next question. More than one loan can be obtained by a borrower. If a request for notice of default was filed, it would be to protect the A. Beneficiary of the first loan, B. Beneficiary of the second loan, C. Truster, D. Trustee. Think about it for a moment. B is the right choice. The beneficiary of the second loan, the junior lien holder, files a request for notice of default to stay informed if the first loan goes into default. That way, they have a chance to protect their financial interests before the property goes into foreclosure. Next question coming up. Under the Equal Credit Opportunity Act, who would be protected from discrimination? A. A parent of twins receiving public assistance who's unable to make the monthly mortgage payments. B. A single person who receives public assistance. C. A person without a job and no apparent means of income. D. A first-time homebuyer with a poor credit history. Think carefully. The correct answer is B. A single person who receives public assistance. The Equal Credit Opportunity Act, or ECOA, protects individuals from discrimination based on factors like marital status, race, or source of income, including public assistance. This means someone receiving public aid can't be denied credit for that reason alone, as long as they otherwise qualify. All right, take a moment for the next one. Promissory notes are A. Used as security for trust deeds. B. Always used when real estate is sold. C. The evidence of the debt. D. Recorded at the county recorder's office. Think it through. C is the correct answer. A promissory note is the borrower's written promise to repay a loan. It lays out the amount owed and the repayment terms. It's not recorded like a deed. It simply serves as the official evidence of the debt between borrower and lender. Let's continue. What does a release clause in a mortgage do? A. Creates a lien that is subordinate only to the lien of taxes and assessments. B. Allows the borrower or lender to extend the due date of the loan. C. Releases a guarantor from additional responsibility under certain terms. D. Allows parts of the property to be freed from the mortgage lien after a certain action is performed. Take a second. The correct answer is D. Allows parts of the property to be freed from the mortgage line after a certain action is performed. A release clause in a mortgage contract allows for the freeing of all or part of a property from a claim by the creditor after a proportional amount of the mortgage has been paid. This can give the borrower full rights to a portion of the property after a specified period of time. Here's the next one. The maximum permissible loan-to-value ratios are A. Fixed by law for conventional loans. B. Not determined by federal statute in the case of Federal Housing Administration FHA loans. C. Based on the competitive analysis of the market by the banker. D. Based on sale price or appraised value, whichever is lower. Think about it. D. Based on the sale price or appraised value, whichever is lower, is the correct answer. Lenders use the lower of the sale price or appraised value to calculate the loan-to-value ratio. This helps protect them from lending more than the property is actually worth. It's a key part of managing risk in the loan process. Next question, coming your way. Can you identify the incorrect statement about the Real Estate Settlement Procedures Act, RESPA, from the options given below? A. Lenders must provide a loan estimate within 3 days of the application, but no later than 7 days before closing. B. The lender must give the buyer an information booklet. C. RESPA regulations cover all residential mortgages. D. The borrower must receive a closing disclosure at or before closing. Take a moment. The right answer here is C. RESPA regulations cover all residential mortgages. RESPA covers the vast majority of residential mortgages, but there are some types of transactions, such as seller-financed purchases and reverse mortgages, that may not be subject to RESPA regulations if they do not involve the federal government in some way. Let's keep practicing. Think carefully on this one. Which of the following is a characteristic of a partially amortized loan? A. By the end of the loan term, there is no remaining balance on the loan. B. All have variable interest rates. C. All have terms of 30 years. D. A balloon payment exists at the end of the loan term. Pause for a moment. Got your answer? Then you know D, it's the right one. A balloon payment exists at the end of the loan term. In a partially amortized loan, regular payments don't fully pay off the loan. So at the end of the term, the borrower owes a large final payment, called a balloon payment, to clear the remaining balance. Let's move on to the next question. Which statement about land sale contracts is accurate? A. The buyer's responsibility to pay property taxes usually does not arise until the seller has delivered a deed for the property. B. The land sale contract is similar to a lease in that the buyer had a right of possession but no rights in the title. C. The seller retains equitable title until the buyer pays the loan in full. D. Land sale contracts are the least secure method of financing for the buyer because the seller retains the title and the buyer is merely the equitable owner. Take a moment to think. If you chose D, you nailed it. The correct answer is land sale contracts are the least secure method of financing for the buyer because the seller retains the title and the buyer is merely the equitable owner. In a land sale contract, the buyer makes payments over time, but the seller keeps legal title until the full price is paid. That makes it a less secure arrangement for the buyer, since they only hold equitable title until the deal is fully completed. All right, let's dive into another financing related question. What is meant by the term takeout loan in real estate financing? A. Net proceeds after discount points and prepaid interest are deducted and received by the borrower. B. A long-term loan to replace a construction loan. C. A loan that requires periodic payments. D. A brief loan typically used to fund construction. Think it through. The correct answer is B. A long-term loan to replace a construction loan. A takeout loan in real estate financing is a type of long-term loan that is used to replace a short-term loan and is typically used to finance the construction or renovation of a property. The takeout loan is intended to provide the borrower with a more stable and predictable source of financing over the life of the property. Let's keep the momentum going. Here's your next question. When the required payments on a real estate loan are insufficient to pay the interest due, the result is A. Negative amortization, B. A greater down payment, C. A reduced term of the loan, D. Increased principal payments. Think about it. The correct answer is A. Negative amortization. Negative amortization is when the required loan payments do not cover the principal and or interest on the loan. This causes the loan balance to increase. Next question. What is the term used for a clause in a trust deed or mortgage that allows the lender to demand immediate payment of the entire unpaid balance upon default? A. Acceleration clause. B. Escalator clause. C. Judgment clause. D. Forfeiture clause. Take a second. The correct answer is A. Acceleration clause. An acceleration clause is a provision in a loan agreement that allows the lender to demand immediate payment of the entire outstanding balance of the loan if the borrower fails to make a payment or violates any other term of the agreement. The purpose of the acceleration clause is to provide the lender with a way to protect its financial interests in the event of a default by the borrower. Let's move on to the next one. Sometimes a broker may earn a commission by demonstrating that they initiated a sequence of events that led to the sale of a property. If a broker brings forward a buyer who is prepared, willing, and able to purchase the property, then the broker would probably A. Have secured the buyer's signature on the sales contract. B. Have an exclusive right to sell listing. C. Have showed the property to the buyer. D. Be considered the procuring cause of the sale. Pause and think, no pressure. The correct answer is D. Be considered the procuring cause of the sale. That's because the primary responsibility of a licensee is to produce a ready, willing, and able buyer, and their commission is based on this role. When a licensee can demonstrate that they are the reason behind a buyer's decision to make an offer on a property, it is referred to as procuring cause. Let's keep practicing. How is the commission earned by a broker typically determined in an agency relationship with their client? A. By mutual agreement. B. By the state law. C. By the local real estate board. D. By the minimums based on the property type. Think you know it. The correct answer is A. By mutual agreement. Commission rates aren't set by law or any board. They're fully negotiable. The client and broker agree on the amount and terms of the compensation. It's all handled case by case. All right, next question. If an owner enters into an exclusive agency listing agreement and later sells the property on their own, which of the following applies? A. The broker is entitled to be reimbursed for expenditures. B. The broker is entitled to 0.5% of their commission. C. The broker is entitled to a full commission. D. No commission is payable. Got your answer. D. No commission is payable is the correct choice. With an exclusive agency listing, the broker only earns a commission if they or another agent brings in the buyer. If the seller finds the buyer on their own, no commission is owed. Let's keep practicing. Here's the next question. Which of the following actions would be considered a violation of RESPA? A. A buyer requesting a particular lender. B. A title insurance company paying $40 for referring clients. C. An agent representing both the buyer and the seller. D. Providing funds to an unlicensed buyer or seller. Take a second. The correct answer is B. A title insurance company paying $40 for referring clients. RESPA strictly prohibits kickbacks or referral fees between settlement service providers. That includes paying a broker or agent for steering clients to a specific title company, no matter how small the amount. Next question. Ryan is in the process of purchasing a residence. He has already signed a valid agreement for sale and now asks the broker for permission to move into the property before the sale officially closes. In this situation, what should the broker do? A. Deny written permission from the seller. B. Get written permission from the seller. C. Deny the buyer permission and get it in writing. D. Deny the buyer permission. Think carefully. The right answer is B. Get written permission from the seller. If a buyer wants early access before closing, it's not up to the broker, it's the seller's call. The buyer must get the seller's written consent, often through an interim occupancy agreement that outlines the terms. Let's move on to another key concept. As well as being responsible for carrying out their duties with diligence, care, and skill, a real estate agent is also required to provide the principal with complete disclosure of all relevant information relating to the agency. If the agent intentionally provides incorrect information regarding these facts, it is likely to be viewed as A. Constructive fraud, B. Misrepresentation, C. Conversion, D. Commingling. Think you've got it? B. Misrepresentation is the correct answer. It can be fraudulent, negligent, or even innocent, but if it's intentional, it can lead to serious legal consequences, including disciplinary action and lawsuits. All right, next up. Which of the following actions would not result in the termination of an agency relationship? A. The agent's abandonment. B. The agent submitted two simultaneous offers. C. The principal's revocation of the agency. D. Fulfillment of the agency purpose. Take a moment to think. The correct answer is B. The agent submitted two simultaneous offers. Submitting multiple offers doesn't end the agency relationship by itself. What matters is whether the agency's purpose is fulfilled, like closing a deal, or if the principal or agent decides to end it through revocation or abandonment. Let's go to the next question. Which of the following options is the most appropriate example of the marketing technique commonly referred to as puffing? A. When a licensee expresses his or her opinions regarding a property, those opinions may be considered material facts. B. If a licensee misrepresents important information or material facts about a property, it may be considered a violation of their professional duties and could lead to legal consequences. C. A licensee suggests that they have a significant network and connections to influential individuals in the region. D. A licensee overstates the value of certain features or benefits of a property. Think it over. D. A licensee overstates the value of certain features or benefits of a property is the correct answer. Puffing is when a licensee exaggerates or overstates features of a property, like calling a small backyard a private oasis. It's not fraud, but it's definitely not a statement of fact. It's considered opinion, and as long as it doesn't misrepresent material facts, it's legal. All right, let's jump into the next question. Oscar is in the process of house hunting and reaches out to a real estate agency. During the conversation, Oscar informs the agent, Brian, that he is interested in the area but is not yet prepared to sign any agreements. Brian is able to assist and accommodate Oscar in numerous ways, with the exception of which of the following actions: A. Brian is permitted to furnish information regarding mortgage interest rates and terms. B. Brian can pre-qualify Oscar for a mortgage. C. Brian is authorized to clarify the distinctions between buyer agency, seller agency, and dual agency to Oscar. D. Brian is permitted to furnish information regarding properties that are available for sale in the area. Think it through. The correct option is B. Brian can pre-qualify Oscar for a mortgage. Until there's a formal agency agreement, Brian can't gather confidential financial details from Oscar. Pre-qualifying requires that kind of information, so it's off limits without an established buyer-agency relationship. Let's move on to the next one. A seller has listed her home for $95,000, and the broker advises a potential buyer to submit a low offer due to the seller's motivation to sell. The buyer offers $80,000, which the seller accepts. In this scenario, A. The broker acted unethically, but the seller was still able to sell their property. B. Any broker is authorized to encourage such bids for the property. C. The broker acted appropriately to secure a prompt offer on the property. D. The broker has violated the agency's relationship with the seller. Think about it carefully. D. The broker has violated the agency's relationship with the seller is the correct answer. A broker has a fiduciary duty to act in the seller's best interest. Advising the buyer to submit a low offer based on confidential information violates that duty. It's a serious breach that could lead to disciplinary action or legal trouble. Next question. Let's keep the momentum. Identify the accurate statement regarding a licensee who acts as a subagent of the listing broker. A. The individual's fiduciary responsibility and foremost loyalty is exclusively to the seller. B. The individual has a fiduciary duty to act in the best interests of both the seller and buyer and equally represents their interests. C. The individual's fiduciary duty and primary loyalty are to the buyer, and they are obligated to act in the best interests of the buyer. D. They only owe each party the normal customer services. Take a second. A. The individual's fiduciary responsibility and foremost loyalty is exclusively to the seller is the correct option. A subagent of the listing broker works under the broker who represents the seller. That means their loyalty and fiduciary duties go directly to the seller, not the buyer. Let's keep going. Broker A with ABC Company listed a property for a seller. Broker B with XYZ Real Estate Company called Broker A and disclosed that he was a buyer's agent. Broker B wrote a contract with his buyer for the sale of the property. What, if any, is the relationship between the buyer's broker, the seller, and the listing broker? A. Dual agency. B. Agency. C. Customer. D. There is not a relationship between the parties. Think you got it? D. There is not a relationship between the parties is the correct answer. In this case, each broker is working with a different client. Broker A with the seller and Broker B with the buyer. That means there's no agency relationship between the buyer's broker and the seller or listing broker. Next up, here's one to test your understanding of agency duties. Apart from being diligent, careful, and skilled, a real estate agent is obligated to fully disclose all facts relevant to the subject of the agency to their principal. If the agent deliberately withholds such information, it would likely be considered A. Constructive fraud, B. Misrepresentation, C. Conversion, D. Commingling. Take your time. Got it? B. Misrepresentation is the right choice. Deliberately withholding key information is misrepresentation, plain and simple. It doesn't matter if it's done intentionally or by omission. The agent is failing their duty to disclose, which can bring legal consequences and loss of license. Here's your next question. Let's read it carefully. Which party did not violate the Civil Rights Act of 1968 in the scenario where a real estate broker presented an offer from a financially qualified minority prospect to a seller, but later a salesperson presented a lower offer from a non-minority prospect, and the seller sold the property at the listed price to a neighbor through the same salesperson who mentioned that he was purchasing the property to maintain the ethnic purity of the neighborhood? A. The neighbor. B. The salesperson. C. Non-minority prospect. D. The seller. Got it? C. Non-minority prospect is the correct answer. The non-minority prospect simply made an offer. Nothing illegal about that. Everyone else in this scenario either acted on or tolerated discriminatory intent, violating the Fair Housing Act. But making an offer, even if it's accepted, doesn't equal discrimination. Let's keep moving. Which of the following is accurate regarding Julia, a licensed real estate agent who refrains from showing properties in predominantly minority neighborhoods to non-minority clients, citing the need to protect the cultural richness of these communities? A. Julia's policy is steering and violates the fair housing laws regardless of her motivation. B. Julia's practice constitutes steering. However, it does not breach fair housing laws as her intentions stem from the desire to preserve culture rather than exclusion or discrimination. C. Julia's practice does not qualify as steering, as she is not trying to limit the rights of any particular minority group. D. Julia's policy results in steering, but it is not her intention to do so. Think it through. The right choice is A. Julia's policy is steering and violates the fair housing laws regardless of her motivation. It doesn't matter why she does it. Steering is steering. Directing clients toward or away from areas based on race or ethnicity is discrimination, even if she believes her intentions are good. Next question. From where does a listing broker receive their authority to accept an earnest money deposit? A. Closing documents. B. Listing agreement. C. Administrative rules and regulations. D. Earnest money agreement. Think you know this one? B. Listing agreement is the correct answer. The listing agreement gives the broker permission to accept earnest money. It's part of their authority as the seller's agent, helping to manage key parts of the transaction from the start. Let's go to the next one. A buyer has correctly revoked their offer after obtaining the property condition disclosure and has requested the return of their earnest money deposit. What must the broker do in this case? A. Obtain the seller's approval before releasing the earnest money. B. Deduct part of their commission from the earnest money with the seller's permission. C. Promptly return the earnest money. D. File an interpleader to determine the disposition of the earnest money. Take a moment. C. Promptly return the earnest money is the correct answer. Once the buyer properly revokes the offer, the earnest money must be returned. There's no commission, no seller approval, and no legal holdup required. It's a straightforward obligation under standard practice. We're doing great. Here's the next one. Which of the following actions violates the Federal Fair Housing Act? A. The owner of a single-family home who is selling it themselves and favors a buyer based on their gender. B. A non-profit private club offering lower rental rates for units to its members, showing preference to them. C. A non-profit church that denies access to its retirement home to any person because of race. D. Discrimination in the sale of a warehouse, favoring or disfavoring a prospective buyer based on their gender. Take a second. C. A nonprofit church that denies access to its retirement home to any person because of race is the correct answer. Even nonprofit organizations are bound by fair housing laws when it comes to residential property. Denying someone housing based on race is illegal, regardless of the organization's mission or membership. The other options fall outside fair housing rules due to exemptions. Let's keep going. Here comes the next question. When an agent or property manager agrees to manage a property belonging to an owner, they do indeed become A. A trustee, B. A fiduciary, C. A lessor, D. A receiver. Think it through. B. A fiduciary is the correct choice. When an agent manages someone else's property, they take on fiduciary duties, loyalty, care, full disclosure, and more. That means they must always act in the property owner's best interest, not their own. Next question. Read this one carefully. If a deed states to Eddie for his life and then to Jason, with Jason as the grantor, what type of interest does Jason have? A. A right of re-entry. B. A remainder. C. A life estate. D. A reversion. D. A reversion is the correct one. Since Jason is the grantor and retains a future interest in the property after Eddie's life estate ends, that's a reversion. The property returns to Jason once Eddie's life interest concludes. Let's keep up the momentum. Here comes the next question. A lease of real property that has a specified duration is regarded as A. An estate at sufferance. B. An estate for years. C. Periodic tenancy. D. A life estate. Think it over. B. An estate for years is the correct answer. Despite the name, an estate for years can be any length of time. It doesn't have to be measured in years. What matters is that it has a clear start and end date. Once that period is over, the lease terminates automatically. All right, next up. Which of the following is not considered real property? A. Leasehold estate in residential properties. B. Uncultivated grove trees. C. Unextracted crude oil. D. Easement appurtenant. Take a moment. The right choice is A. Leasehold estate in residential properties. Leasehold estates are classified as personal property, not real property. Even though they relate to land use, they're temporary interests and don't involve actual ownership of the real estate. Let's move on to the next one. Which of the following is considered a fundamental requirement of a grant deed? A. Recordation. B. Parties capable of receiving the grant. C. Acknowledgement. D. Offer and acceptance. Got it? Option B, parties capable of receiving the grant, is the correct answer. For a grant deed to be valid, the receiving party must be legally capable of owning property. That's the essential element here. Things like recordation and acknowledgement may affect enforceability, but they aren't required to make the deed legally valid. Let's jump into the next question. What is the antonym of alienation? A. Hypothecation. B. Subrogation. C. Subordination. D. Acquisition. Take a second. D. Acquisition is the correct answer. Alienation is about giving up ownership. Acquisition is the opposite. It's about gaining it. Whether you inherit, buy, or are gifted a property, that's acquisition. The other terms don't represent direct opposites. Let's keep going with the next one. If you possess an undivided interest in common areas as well as a separate interest in a specific unit of an industrial, commercial, or residential building, what do you own? A. A limited partnership. B. A cooperative apartment. C. A community apartment project. D. A condominium. Think it through. D. A condominium is the correct answer. Condominiums give you full ownership of your unit and shared ownership of the common areas. That undivided interest means you share the space with others. You can't carve out your own portion of the lobby or pool. Next question. Stay focused. What is the term for an arrangement in which Carl is responsible for paying the property taxes on a rental property as per the terms of his lease agreement? A. A percentage lease. B. A sandwich lease. C. A net lease. D. A gross lease. Got it? C. A net lease is the right choice. In a net lease, the tenant covers not just rent but also expenses like property taxes. It's common in commercial leasing and it shifts more responsibility to the tenant compared to a gross lease. All right, here's the next one. Pay close attention. If Lara granted a property to Gina with the condition that the property would be forfeited if alcohol was sold on the premises due to Gina's drinking problem, what type of estate would Gina possess? A. Fee simple absolute. B. Life estate. C. Fee simple defeasible. D. Estate in sufferance. Think you've got it? C. Fee simple defeasible is the correct answer. A fee simple defeasible means ownership can be lost if certain conditions aren't followed. Gina owns the property. but only if she abides by the terms set by Lara. Break the condition, and the estate can end. Let's move on to the next question in this round. If a property owner thinks that the county assessor has overassessed their property's value, which entity should they contact? A. Assessment Appeals Board. B. County Tax Collector's Office. C. State Controller's Office. D. County Board of Supervisors. The correct answer is A. Assessment Appeals Board. If you believe your assessed property value is too high, you don't call the tax collector, you file an appeal. The Assessment Appeals Board handles those disputes and can reduce the valuation if your evidence supports it. Let's keep going with the next question. Which type of title insurance policy is most commonly selected by buyers of a real property? A. A certificate of title. B. An ALTA policy. C. A leasehold policy to protect against the rights of tenants. D. A standard policy. Think it over. D. A standard policy is the correct answer. Most buyers choose a standard title insurance policy. It protects against common title issues like forged documents, errors in public records, or undisclosed heirs, anything that might put ownership at risk after closing. Let's move on to the next question. A title plant encompasses the title records of properties within A. State. B. City. C. Town. D. County. Got your answer? D. County is the correct choice. A title plant is a database of title records. Organized by county, title companies rely on these to research property history, verify ownership, and issue accurate title insurance policies. Next up, the title to real estate passes when a valid deed is A. Delivered and accepted. B. Signed and recorded. C. Filed and microfilmed. D. Executed and mailed. Think carefully. A. Delivered and accepted is the right answer. Signing a deed isn't enough. For ownership to legally transfer, the deed must be delivered to the buyer and accepted. That's the moment the title passes, not when it's recorded or mailed. Let's keep it going. What is typically meant by rehabilitating real property? A. The property must be replaced to obtain its highest and best use potential. B. The use of the property will be changed. C. Design changes must be made to the property. D. The property will be restored to good condition. Take a second. D. The property will be restored to good condition is the correct answer. Rehabilitation means fixing up the property, not replacing it. It's about restoring it to a good, usable state, whether that involves structural repairs, system upgrades, or aesthetic improvements. Let's tackle one more. As one of the qualifications for a depreciation deduction for income tax purposes, the real property must be A. Encumbered, B. Personal residence, C. Improved, D. Unencumbered. If you picked C. Improved, you're right. C is the correct answer. To claim depreciation for tax purposes, the property must be improved. That means it has buildings or structures on it. Land itself doesn't depreciate, but improvements do, because they wear out or become outdated over time. Let's jump into the next question. A quitclaim deed to a parcel of real property conveys only the present interest, right? And title of the A. Occupant, B. Grantor, C. Grantee, D. Lessee. Take a second. The correct answer is B. Grantor. A quitclaim deed offers no warranties. It simply transfers whatever interest the grantor currently holds, nothing more, nothing less. If the grantor owns nothing, the grantee gets nothing. It's commonly used in non-sale transactions like gifts or transfers between family members. Let's keep going. Here's the next one. For what reason can the cost basis of a single-family residence be adjusted? A. Room or patio addition. B. Mortgage payments. C. Interest paid on a loan. D. Fire insurance premiums. Think it through. A. Room or patio addition is the correct answer. Capital improvements, like adding a room or a patio, increase the cost basis of the home. That matters when calculating capital gains at the time of sale. Regular expenses like interest and insurance don't affect the basis. Next question coming up. If Ronald exchanges an income property with an adjusted cost basis of $130,000 and a fair market value of $180,000 for another income property valued at $220,000 with no loans against them and no adjustment for the difference in value, what will be the basis of the new property for Ronald's federal income tax purposes? A. $170,000. B. $180,000. C. $130,000. D. $220,000. Ready? C. $130,000 is the right answer. In a 1031 exchange, Ronald's adjusted basis carries over to the new property. So, even though the value of the new property is higher, the tax basis stays the same, $130,000, because there was no cash or debt involved in the trade. All right, let's go to the next question. In a sale leaseback agreement where Stephanie sells her ranch to Nathan and then leases it back, which of these statements about this arrangement is true? A. No one becomes the lessor. B. Stephanie retains title to the ranch. C. Nathan is the lessor. D. Stephanie is the lessor. Think you got it? C. Nathan is the lessor is the correct answer. Once the property is sold, the buyer becomes the lessor and leases it back to the seller, who becomes the lessee. Nathan owns the property now, so he's the one leasing it to Stephanie. Let's keep going. Dan conveys property to Lara by delivering a deed that contains 5 covenants. This is most likely A. Tax deed. B. Grant deed. C. Quitclaim deed. D. Warranty deed. The correct answer is D. Warranty deed. A warranty deed includes multiple covenants, guarantees about the title status, and the seller's right to transfer it. It's the strongest form of deed protection for the buyer. Unlike a quitclaim deed, it assures the buyer that the title is clean and valid. Next up, where could a title company search records to conduct a title search? A. County Recorder's Federal Land and County Clerk's Office. B. County Clerk's Office. C. Federal Land Office. D. County Recorder's Office. Got your answer? If you said A, County Recorder's Federal Land and County Clerk's Office, that's correct. A title search is a detailed examination of the historical records concerning a property. These records include deeds, court records, property and name indexes, and many other documents. The purpose of the search is to verify the seller's right to transfer ownership and to discover any claims, defects, rights, or burdens on the property. In the United States, these records are typically held at the local level in county or municipal offices. Moving on, what does the legal term quiet title action refer to? A. Court action to remove a cloud on the title. B. Acquiring real estate through a fictitious or sham transaction. C. Taking measures to address a disruptive tenant who is causing excessive noise. D. Foreclosure action. What do you think? A. Court action to remove a cloud on the title is the right answer here. That's cause a quiet title action is a legal proceeding used to settle disputes over the ownership of a property and to clear defects, ambiguities, or conflicting claims that might cloud the title. A cloud on the title refers to any claim, encumbrance, or potential interest that could impair the title's validity or create uncertainty regarding ownership. Let's keep going. When real estate under a state for years is sold, the lease A. is valid but unenforceable. B. binds the new owner. C. ends with the conveyance. D. is subject to termination with proper notice. Take a second. The correct answer is B. binds the new owner. The most frequently used type of rental agreement is a tenancy for years, which obligates all future property owners to abide by the terms of the lease for the duration of its term. Let's keep practicing. What happens if a salesperson functions as an independent contractor? A. All of the listings belong to them. B. They control their own working hours. C. Their broker is required to deduct income tax from their commission payments. D. Their broker will establish their work schedule and advertising techniques. Think it through. B. They control their own working hours is the right answer. Independent contractors have control over how and when they work. While they must meet performance expectations, they aren't subject to strict work schedules or tax withholding, unlike employees. And the next question is, which of the following best describes the physical boundaries of land? A. The surface of the earth and all water and minerals on or below the surface to the center of the earth. B. The surface of the earth and infinite space above the surface. C. The center of the earth and infinite space above the earth. D. The surface of the earth and the air right above the surface to the point defined by local zoning. Take a second. C. The center of the earth and infinite space above the earth is the correct answer. Legally, land extends from the center of the earth all the way up to infinite space. This definition includes minerals below, water rights, and air rights, unless otherwise limited by local regulations. Let's move on to the next question. A competent property manager. A. Does not appease their tenants by repairing tenant-owned equipment. B. Does not screen the tenant's ability to pay. C. Does not study rental rates in the area. D. Does not consider the type of business the tenant has. Ready? A. Does not appease their tenants by repairing tenant-owned equipment is the correct choice. A skilled property manager knows their job is to protect the owner's investment, not to fix tenant-owned items. They focus on maintaining the property, setting fair rent, and selecting qualified tenants, not handling personal equipment repairs. Next question. Identify the correct statement regarding condominiums. A. The covenants and restrictions outline the property taxes that the condominium community is obligated to pay. B. A condominium unit may be mortgaged like any other parcel of real estate. C. If a unit owner fails to pay their property taxes, the remaining unit owners will be responsible for covering the defaulted taxes. D. If a unit owner neglects to pay the monthly maintenance fee, it may result in the foreclosure of the entire community. Think it through. The right answer is B. A condominium unit may be mortgaged like any other parcel of real estate. Each condo unit is treated as a separate real estate parcel. That means it can be financed with a mortgage just like a single family home. No special structure needed beyond standard lender requirements. Let's keep going. Who is the lender required to provide a detailed loan estimate at the time of loan application or within 3 business days under TRID? A. The buyer and seller. B. The buyer. C. Neither the buyer nor the seller. D. The seller. Take your best guess. What do you think? If you said B, the buyer, you're absolutely right. Try D requires lenders to give the loan estimate to the buyer, not the seller, within 3 business days of receiving a completed loan application. This document lays out the loan terms and costs so the buyer can make an informed decision. All right, take a moment and let's go to the next question. What is the main purpose of the federal fair housing law? A. To eliminate prejudice wherever it exists in the United States. B. To build housing units designed primarily for minority groups throughout the United States. C. To guarantee separate but equal housing units for all people in all of the states. D. To prohibit discrimination in housing for all persons throughout the United States. Take a moment to think it through. D. To prohibit discrimination in housing for all persons throughout the United States is the correct answer here. The Fair Housing Act is about equal access. It prohibits discrimination in the sale, rental, or financing of housing based on protected classes like race, religion, sex, or disability. It applies nationwide, no exceptions. Let's keep up. Here is the next one. What may a listing agent do if their client refuses to provide a seller's property disclosure to the buyer? A. Provide the buyer with a disclaimer signed by themselves. B. Provide the buyer with a disclaimer signed by the seller. C. Present the buyer with a disclaimer that has been signed by their employing broker. D. offer a completed disclosure to the best of their ability. Give it a little thought. The right choice? It's B. Provide the buyer with a disclaimer signed by the seller. If the seller refuses to provide a full disclosure, the agent must present a signed disclaimer, but it has to come from the seller. The agent can't guess or fill it out on the seller's behalf. That would be a legal and ethical issue. All right, let's keep going with another one. How is it called an agreement between Elias and Lars, where Elias grants Lars the right to offer, sell, and distribute services under a marketing plan described by him and under his trademark name, Elias Real Estate Services? A. Franchise agreement. B. Real property securities transaction. C. Personal securities investment. D. Business opportunity transaction. Pause if you need to and consider your answer. The correct choice is A. Franchise agreement. A franchise agreement gives Lars the right to run his business using Elias's brand, systems, and marketing plan. This setup is common in real estate, fast food, and other industries where branding and structure are key to growth. Let's move on to the next question. To create a lease for more than 1 year, it is not necessary. A. To have both the lessor's and the lessee's signatures. B. To include a termination date. C. That the lease be in writing. D. To define the amount of rent and the method of payment. Think about it for a second. The correct answer is A, to have both the lessor's and the lessee's signatures. Even though it's best practice, a lease can still be legally enforceable without both signatures as long as the actions of the parties show agreement. The key is that the lease must be in writing if it exceeds 1 year. Next question coming up. What is the length of the safety clause in a listing agreement? A. 21 days. B. 60 days. C. 7 days. D. Whatever is agreed upon. Take your time here. D is the right answer. Whatever is agreed upon. There's no fixed length for the safety clause. It's entirely negotiable. The broker and the seller must agree on the time frame during the listing agreement. Let's keep it rolling. Which of the following statements is true of an exclusive right to sell listing agreement? A. The owner must commit to purchasing title insurance coverage. B. Without the sales agents and sponsoring brokers' full names and license numbers, the agreement will be invalid and unenforceable. C. It must specify a definite termination date not subject to prior notice. D. Any such agreement must include a form for the seller's property disclosure. Ready with your choice? C. It must specify a definite termination date not subject to prior notice is the correct answer. A valid exclusive right to sell listing must have a definite termination date. It cannot be open-ended. That's the one non-negotiable legal requirement. Let's tackle the next one. What method do appraisers use for determining the value of real estate? A. Cost approach. B. Income approach. C. Sales approach. D. All of the above. Give it a little thought. D is the correct answer. All of the above are correct. Appraisers can use any of the three major approaches depending on the property type and purpose of the appraisal. Sales comparison is most common for homes, the income approach for rental properties, and the cost approach for special use or new buildings. Great job making it through all 75 questions. Every round of practice gets you closer to passing your real estate exam with confidence. For more questions, study guides, and tips, visit lexawise.com. The link is in the description. Don't forget to subscribe, hit the bell icon, and keep practicing.